You're listening to Wiley's Political Law Podcast, a series of podcasts on election law, ethics, and government investigations. In each podcast, attorneys at Wiley, a Washington, D.C. law firm, break down an aspect of the political law landscape with our unique insight into issues faced by our clients.
Welcome, everyone, to our third episode of our podcast series on H.R. 1, the reform legislation that's been introduced for the second time by the House Democrats in the House and is set to be considered in the next week or so, this being the end of February 2021. And I'm Mark Renaud. I'm a partner in the Election Law and Government Ethics Group at Wiley. And today we're going to talk a little bit about how H.R. 1 potentially affects the Lobbying Disclosure Act and who is a lobbyist and the regulation of federal lobbyists, something that hasn't been amended or adjusted since 2007 when the Honest Leadership and Open Government Act, HLOGA as it's called, was passed and ushered in a whole regime of ethics changes and lobbying changes. Like I said, this is the third episode. Previous episodes involved discussions about H.R. 1 changes with respect to proposed changes with respect to corporations and trade associations and disclosures and disclaimers and certifications. The second episode involved how H.R. 1 potentially affects web platforms and broadcasters and other types of advertising issues. And we're going to at least have one more episode, if not more. The next episode that's planned is will take on the proposed amendments to the structure of the Federal Election Commission and how that would affect PACs and other federal PACs and other participants in federal elections. But today, like I said, we're going to talk about the Lobbying Disclosure Act and how H.R. 1, if passed, would affect it as introduced. So this is the text of the bill that's been introduced, and the text is going to go directly, the bill is going to go directly to the floor, is our understanding of the House, since it was passed in various forms back in 2019. So the first and major way, the most significant way that H.R. 1 proposes to amend the Lobbying Disclosure Act, or the LDA, is to reduce the registration threshold from 20% to 10%. The threshold, for those who are not as familiar with LDA as I am, since I deal with it every day, that's what it takes for someone to become have to be registered as a federal lobbyist. So currently, under federal law, there are two factors that have to be fulfilled before one has to be registered as a federal lobbyist. And this is for the in-house. And for outside lobbyists, there's a couple other factors. But for in-house lobbyists, the main factors are, first, that you make a lobbying contact, which is a communication on legislation, policy, positions, contracts of the U.S. government. Make a communication about that with a covered official, which means a member of Congress, a staffer of Congress, or a political appointee in the executive branch. If you make more than one of those contacts, then the registration threshold moves to the second factor, which currently is that you spend 20% or more of your time for your company or trade association or other employer in a calendar quarter engaged in those kinds of communications or preparation, strategy, research, and other activities that support your own communications or the communications of others. So you've got to spend, not only do you have to make more than one contact, so if you're just a back office person doing research and never communicate to staffers on the Hill or political appointees or members of Congress, then you're not going to become a lobbyist. And second, you could make those contacts and make quite a few, but in a calendar quarter, you spend less than 20% of your time, so less than 1 day a week during the quarter, doing those kinds of communications or preparing or strategizing about those kinds of communications, then you don't have to register. So, not everyone who lobbies Congress or the executive branch has to register as a lobbyist. This bill would move that threshold, if it was passed, down to 10%. And knowing the clients that I have and that our firm has in this space, that would include a lot of people who heretofore have not had to register as federal lobbyists, who would then be registered as federal lobbyists. Now, that's not the end of the world to be registered as a federal lobbyist. I always joke that maybe your mom won't speak to you anymore. Lobbyists don't like that joke usually, but you get the idea. Not everybody wants to be seen as a lobbyist, and so that may cause them to have to curtail their lobbying activity further to be below 10% or divided amongst other teammates, because it's a per person threshold, not a aggregate per company or trade association threshold. But I know there's a lot of people that are between 10% and 20%. And so, either they're going to have to work more hours so the denominator goes up and their percentage of their time goes down spent in lobbying, or they're going to have to cut back in their lobbying time. Again, if this is passed, it would cut from 20% to 10% threshold. The second is really an attempt by those who put forward the legislation to undo what they refer to as, some people refer to as the Daschle exception, Senator Daschle, who did, and I don't have any, inside details on this, but the allegations is that folks like Senator Daschle have done a lot of strategic presentations, strategic advice over the years, and may even make some contacts on behalf of a company or a trade association or other kind of entity, nonprofit, but that they weren't lobbying. They weren't preparing for lobbying. They weren't strategizing about lobbying. They were just counseling. Strategic counseling, I think, is usually what it was called. And some people call those shadow lobbyists, et cetera. And not getting into any particular of any case, because that's not an issue here. But this H.R. 1 proposes to go after those people who engage in such counseling by a fairly complicated definition, but trying to pull a lot of that strategic counseling that relates to lobbying into what is lobbying, and that would count for the 10% threshold, for example. And so, that's an attempt, again, to get more people registered, not to have shadow lobbyists, just like moving 20% to 10% on the threshold is an attempt to get more people on the record, filing reports, knowing how much they get paid or how much they spend and who they are and what issues they're lobbying. The third way that H.R. 1 goes after federal lobbyists and the current lobbying law is that they want federal lobbyists, those who are registered, to have to identify themselves when they make contact with a member of Congress, congressional staffer, or political appointee, that they'd have to identify themselves as a federal lobbyist and identify who their clients are. Currently, you don't have to say anything. You can just say, "Hey, I'm Mark, and I'm here and to talk about H.R. 1 or H.R. 2, whatever the legislation may be, or the other kind of covered issues, political programs of the United States, etc." This one would have to say, and I'm not a registered lobbyist, but it's just an example. "Hi, I'm Mark Renaud. I'm a registered lobbyist for the firm, Wiley, and I represent whatever my client is." That's how this proposal would be. Currently, if you are asked by a covered official, you are required to disclose these kinds of things, just like if you ask an official whether they're a covered official or not, and if they are a covered official, they have to identify that they are. It doesn't come up very often in my experience, but definitely this would be a chilling effect, papers sent across, et cetera, saying, "Hey, I'm a registered lobbyist," things like that. But it's obviously, again, a movement to have more transparency in this area. There's a couple provisions in there about lobbyists not being able to receive compensation for countries engaged in human rights violations as determined by the president. That's, an interesting kind of miscellany provision. And then the final thing that really directly affects federal lobbyists is and this may not be a major issue for anybody, but on candidate reports and other PAC reports and other filings with the Federal Election Commission, there's a requirement, again, if H.R. 1 were passed in its current form, that registered federal lobbyists are identified as such on those reports. So, there's not a lot of, this doesn't mean that the lobbyists would have to do anything particularly. It just means that the PACs and the committees and party committees, et cetera, candidates would need to, get a list of federal lobbyists, run their reports against those lists, and put them in their reports. However, the Federal Election Commission said it needed to be done. Not really a big issue for corporations. They know who their lobbyists are. The same with trade associations. But for a candidate committee or something, it's just another step that they'd have to do. So that's how the proposed rule affects Lobbying Disclosure Act generally. And I will note, however, that the LDA doesn't actually regulate grassroots lobbying. We've been through those battles in the past, 2007 and before, and it does not regulate grassroots lobbying, even though, like, the tax law does regulate grassroots lobbying. But H.R. 1 and its many provisions and its 600 pages has some other issues that affect grassroots lobbying. So not federal lobbyists directly, but you should know that there's some provisions regulating through the Federal Election Commission, of no doubt, grassroots communications trying to influence judicial nominations and confirmations, an expansion of what's called electioneering communications, which are ads that don't say vote for or vote against the candidate, but mention their name or use their picture. And that would be expanded in the days before elections to not just TV and radio, but to digital platforms. So that, again, there's lots of pieces of legislation pending when primaries are being run and people have legitimate lobbying needs to run those kinds of grassroots communications, but they would be classified in a type of political communication and regulated with disclaimers and disclosure. And also, the H.R. 1, as we discussed in one of the other episodes, would expand some other regulated communications that promote or support the election of a candidate, which is pretty broad and subjective, and so, again, could capture more legitimate, bona fide grassroots lobbying activity that mentions senators, because you say call your senator or call your congressperson, and could definitely curtail the ability of certain groups to engage in this kind of activity or have to approach it in a different way. So H.R. 1 affects lots of things. If it were passed, we'll see what the House has to do. But thanks for tuning in today, and we hope you enjoy all the episodes that we have on the proposals in H.R. 1. Thanks.
Thank you for tuning in to the Wiley Political Law Podcast, brought to you by the attorneys at Wiley Ryan LLP. If you enjoyed this episode, we encourage you to follow us on SoundCloud. For additional resources and materials, head over to wiley.law. Thank you for listening. The views, information, or opinions expressed during episodes are solely those of the individuals involved and do not necessarily represent those of Wiley Ryan LLP and its employees. The material contained in this podcast is not intended to be and is not considered to be legal advice. Transmission is not intended to create and receipt does not establish an attorney-client relationship.